Sir, good evening, sir.
Good evening.
So 2 more minutes to go, sir. Sharp 6, we will start the program. 1 more minute to.
Okay.
ಯಾವ್ದು ಅಕಾಡೆಮಿ?
Can we begin the program, sir?
Sure.
A warm good evening to one and all. Advocates Association Bengaluru and Advocates Academy Bengaluru is hosting the first series of webinar 2025. Today, the topic chosen is Jurisdiction of Civil Courts, Section 9 of CPC. And the resource person we have with us is a very eminent resource person, and sir needs no introduction. Sir has put in 40 years of service as a judge, and sir also has academic bent of mind. Sir has been regularly visiting Judicial Academy and has been training the upcoming presiding officers. Sir, on behalf of Advocates Association Bengaluru and Advocates Academy, sir, I extend a very warm welcome to you, sir.
Thank you.
Over to you, sir.
Okay. Good evening, Mr. Trivikram, and good evening all the participants. Thank the Advocates Association Bengaluru and Advocates Academy, and also Trivikram, the coordinator of this program, for the second opportunity given to me. The topic that I have chosen for discussion is Section 9 CPC. The reason why I have chosen this is this. I find from my experience as a trial judge for nearly 31.5 years, and now after retirement as an arbitrator, whether it is in the written statement, the first sentence in all cases says, the suit is not maintainable in law or facts, the court has no jurisdiction. Which is that law which prohibits that suit is nowhere stated. It should be very clear what is that jurisdiction which the defendant is questioning. Is it the territorial jurisdiction of the court? Is it the pecuniary jurisdiction of the court? Is it a bar created by any special enactment that bars the jurisdiction of the court? Is not clear from the statement at all. Maybe as an exception we find some such thing. So this practice of making a vague statement only to make a beginning of the written statement, suit is not maintainable in law and facts court has no jurisdiction. This is precisely the reason why I thought that I should take up this subject today. As all of us know, there are three kinds of jurisdiction. One is territorial jurisdiction, that is covered by section 16 to 20 CPC. I am not dealing with it. There is no point in dealing with it also. It is very simple. It doesn't require any decision or interpretation. The reading of those provisions would itself tell us what the territorial jurisdiction of a civil court is. In fact, section 9 doesn't deal with it at all. The second is pecuniary jurisdiction. Civil Procedure Code does not deal with pecuniary jurisdiction at all. I am saying it with an amount of confidence and command. CPC by itself does not deal with pecuniary jurisdiction. Section 15 CPC only says all suits will have to be filed by the court of the lowest grade competent to try it. That's all it says. which is that lowest court of lowest grade, which has that pecuniary limit, is nowhere stated. So different states have civil courts act, and so too the Karnataka state has this Karnataka Civil Courts Act, which gives which states what the pecuniary jurisdiction of a civil judge, senior civil judge is. Of course, there is an amendment to it. That amendment has been stayed. It's a different perspective. You need to worry about it today. Apart from that, we have the Bangalore City Civil Courts Act. We have also the Karnataka Small Causes Courts Act. Karnataka Small Causes Courts Act, apart from telling what the pecuniary jurisdiction is, what matters can be entertained by a small cause court is also stated in the Karnataka Small Causes Courts Act. I am not going into details of the Karnataka Civil Courts Act or the Bangalore City Civil Courts Act or Karnataka Small Causes Courts Act. I have drawn the attention of the participants to these three enactments only to impress upon them that pecuniary jurisdiction is to be found in these three enactments. And as far as the Small Causes Courts Act is concerned, apart from pecuniary jurisdiction, what matters are cognizable by a small cause court, what matters are excluded from the cognizance of a small cause court is contained in that act. The third is jurisdiction over the subject matter of the suit or inherent jurisdiction. Or inherent jurisdiction. This is precisely what Section 9 CPC tells us. This is extremely important for lawyers practicing on the civil side, more particularly the youngsters. It is jurisdiction over the subject matter of the suit or inherent jurisdiction. Let there be no confusion between inherent jurisdiction and inherent powers recognized by Section 151 CPC. 151 CPC does not provide for inherent jurisdiction. It recognizes the inherent powers already possessed by a court by virtue of its establishment or existence. So Section 9 is essentially concerned with the jurisdiction over the subject matter or inherent jurisdiction. Let us have a look at Section 9 CPC before we go to the decisions, important decisions on it. Courts to try all suits unless barred. The courts shall, subject to the provisions herein contained. The words subject to the provisions herein contained are found in the bracket. Let us not exclude what is mentioned in the bracket. It has serious implication. Subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. What a suit of a civil nature is, everybody knows: property disputes, money claims, then disputes regarding caste, age, status, everything is covered. Explanation 1 and 2 also tell us, which are also considered as suits of civil nature. I am not very much on that. I am more particularly about this jurisdictional aspect. So three things emerge from Section 9. Every suit of a civil nature is cognizable by a civil court. Exceptions are subject to the provisions herein contained. If CPC itself has certain provisions which bar a suit, then though the suit is of a civil nature, that suit cannot be entertained. Second is either expressly or impliedly barred. If a statute, if a special enactment either expressly bars the jurisdiction of a civil court or impliedly, if there is something in the enactment which gives us an indication that a civil suit is barred, a civil court does not have jurisdiction, then it will not have. I repeat, three things are to be found from a close reading of Section 9. A bar created by CPC itself, an express bar created by a specific an implied bar which can be inferred from a reading of the special enactment. Now, first let us look into the bar created by CPC, subject to the provisions herein contained. Now, the next section, section 10, is important. Stay of suit, popularly called sub judice, section 11, res judicata. A files a suit against B for declaration of title, injunction, and other reliefs in respect of a particular property. That suit is pending. Subsequently, B files another suit against A in respect of the same subject matter. So, section 10 says the subsequent suit needs to be stayed. Certainly, the subsequent suit is a suit of a civil nature. There can be no dispute that a suit for declaration of title and injunction in respect of a removable property is a suit of a civil nature. But section 10 bars the court from proceeding with the trial of that suit. Therefore, this is a bar created by CPC itself. That is why subject to the provisions herein contained. Section 11 CPC. A had filed a suit against B in respect of a subject matter. The suit was, let us say, the suit was decreed. Subsequently, B files a suit against A in respect of the same property. Or the suit filed by A against B was dismissed. A again files another suit against B. Here, the principle of res judicata says, if in a former suit, a matter was directly and substantially in issue, and that was decided by a competent court, a subsequent suit does not lie. This is all in brief section 11. I am not dealing in greater detail about section 11 because that requires a completely different session. I am not on that. What I am trying to impress upon the audience is section 10 and 11 found in CPC itself. They bar a suit. One bars the trial of a suit, other bars taking cognizance of the suit itself because there is already a form of suit pending or a formal suit has already been decided. There is no dispute that they are suits of a civil nature. ನೀವೇ ರಿಸೀವ್ ಮಾಡಿಬಿಟ್ಟು ಆಂಟಿ ನೋಡಿ ಹೇಳ್ಬಿಡಿ. Next, go to section 12. Bar to further suit, where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action, he shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies. I reread it. Where a plaintiff is precluded by rules, rules are also defined in section 2, subsection 18 CPC. Rules means rules and forms contained in the first schedule are made under section 122 or 125. 122 is the section which gives the power to the High Court to frame rules for the working of the trial courts. That is why we have the Karnataka Civil Rules of Practice. 125 High Court rules. Let us not worry about it. Rules and forms contained in the first schedule. What does the first schedule of the Civil Procedure Code contain? It contains the order portion of the Civil Procedure Code, commencing from Order 1 and ending with Order 51. As all of you know, each order has different rules. Order 1, Rule 1, Order 2, Rule 2, right, Rule 3, like this. So, rules found in the order portion of the Civil Procedure Code, if there is any bar created by those rules, even though the suit is of civil nature, that cannot be proceeded with by the court. Let us have a look at those rules. First one is Order 2, Rule 2, CPC. Check. I am making it very clear that I am not dealing with these separate orders today. I am only drawing your attention to the fact that there are certain provisions in the Civil Procedure Code which bar a suit even though they are suits of a civil nature. Let us have a look at Order 2, Rule 2. Order 2, Rule 2, Sub-Rule 1. Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect to the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit into the jurisdiction of any court. Sub-Rule 2. Where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. I am not giving any details about Sub-Rule 2. This is not the occasion. If I do it, I will not be able to complete the rest of Section 9. So, Sub-Rule 2 of Rule 2 of Order 1, Order 2 also creates a bar for a suit, though it's a suit of a civil nature. Sub-Rule 3. A person entitled to more than one relief in respect to the same cause of action may sue for all or any of such reliefs, but if he omits, except with the leave of the court to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. So, Sub-Rule 3 of Order 2 also creates a bar. Then let us go to Order 9, Rule 9, Sub-Rule 1. Order 9, Rule 9, Sub-Rule 1. For that, we need to read Order 9, Rule 8 first. Where the defendant appears and the plaintiff does not appear when the suit is called on for hearing, the court shall make an order that the suit be dismissed. The other part of it is not necessary. This is what is usually done. Suit is dismissed for non-prosecution or for default. What is its consequence? That is provided in Sub-Rule 1 of Rule 9 of Order 9. Where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect to the same cause of action. The fresh suit is certainly a suit of a civil nature, but a bar is created by one of the provisions of CPC, that is Order 9, Rule 9, Sub-Rule 1. It says, however, the plaintiff can make an application for bringing back the suit, for restoring the suit, if the court is satisfied that there are sufficient cause for his non-appearance. That is why usually a miscellaneous petition is filed for restoration of the suit under Order 9, Rule 9 CPC. Now, there is an exception to this. Order 9, Rule 9, Sub-Rule 1 bars a subsequent suit in respect of the relief claimed in the previous suit, which was dismissed for non-prosecution. There are two recognized exceptions. One is a suit for redemption of mortgage. ILR 1991 Karnataka 1213. ILR 1991 Karnataka 1213. Kalayya versus Lingamma. Kalayya versus Lingamma. Next, ILR 2000 Karnataka 1402. ILR 2000 Karnataka 1402. Kantamma versus H.N. Reddy. Third one is 2011 6 SCC 780. 2011 6 SCC 780 LK Trust versus EDC Limited. In these three cases, it has been held that it is the right of a mortgagor to get the property redeemed at any time before the expiry of the period of limitation. Therefore, if a previous suit for redemption has been dismissed for non-prosecution or withdrawn, that will not bar a fresh suit. So, a suit for redemption of mortgage is an exception to Sub-Rule 1 of Rule 9, which bars a fresh suit when a previous suit has been dismissed for non-prosecution. With regard to a partition suit, we have two judgments. ILR 2005 Karnataka 3177. ILR 2005 Karnataka 3177. Babu Rao versus Iranna. The next one is ILR 2012 Karnataka 4129. ILR 2012 Karnataka 4129. It is a decision of a division bench. S.K. Lakshmi Narsappa versus B. Rudraya. In these two suits, it is held that Partition is a recurring cause of action. Even the first suit for partition is dismissed for non-prosecution or default. A second suit is perfectly maintainable. It has been held by a single judge in this Babu Rao and by a division bench in S.T. Lakshmi Narsappa versus B. Rudraya. I request the participants to read the second judgment of the division bench because apart from examining the scope of Order 9 Rule 9, Sub-Rule 1 in the context of a partition suit, various aspects of Hindu law have been covered in that judgment. It's worth reading. The next bar that is created is by Order 11 Rule 21 Sub-Rule 2 CPC. Order 11 Rule 21 Sub-Rule 2. Well, again, this is an order which requires a detailed session. I am not on that. To minimize oral evidence, interrogatories, that is, questionnaire is given to the opposite party, whether he would admit a particular fact and all that. If he admits that to that extent, there will be no need for recording oral evidence. These interrogatories are delivered. Sometimes they are called upon to produce documents. So applications and other things are filed. Some order is passed. What is the effect of non-compliance? Order 11, Rule 21, Sub-Rule 1. Where any party fails to comply with an order to answer interrogatories or for discovery or inspection of documents, he shall, if a plaintiff be liable to have his suit dismissed for want of prosecution, and a defendant to have his defense, if any, struck out, and to be placed in the same position as if he had not decided, and the party interrogating or seeking discovery or inspection may apply for an order to the court to that effect. Sub-Rule 2. Where an order is made under Sub-Rule 1, dismissing any suit, the plaintiff shall be precluded from bringing a fresh suit to the same cause of action. Therefore, whenever there is an order for answering interrogatories or for making discovery or inspection of documents, be careful. If you are appearing for the plaintiff, the suit is liable to be dismissed. Fresh suit is totally barred. If you are appearing for the defendant, your defense is liable to be struck down. Of course, the Honorable Supreme Court and our High Court have said court should be too slow in passing an order under Order 11 Rule 21, but they use the word contumacious conduct of the plaintiff or the defendant. If his conduct is contumacious, then the defense is liable to be struck out and struck off, and suit is liable to be dismissed. The next bar is Order 22 Rule 9 Sub-Rule 1. As all of you know, if an application to bring the legal representatives on record is not filed within 90 days from the date of death, not from the date of knowledge, please be clear about it, from the date of death, the suit abates automatically. There are two types of abatement recognized by Order 22. One is abatement because no right to sue survives. Cause of action dies. That is based on the principle actio personalis maritalum persona by Section 300 of the Indian Constitution. The other abatement is on account of the fact that application to bring the LRs on record is not filed within 90 days from the date of death. Then the remedy is he has to make an application for setting aside the abatement. For that, the limitation is 60 days from the date on which the suit abates. If the application for setting aside the abatement under 22 Rule 9 is not filed within 60 days, then an application can be filed under Section 5 of the Limitation Act for condonation of delay of what? Condonation of delay in filing the application for setting aside the abatement and not for making an LR application. I have seen lawyers making application for condonation of delay in filing the LR application. It is incorrect. There is nothing like condoning the delay in filing an LR application. It is condoning the delay in filing an application for setting aside the abatement. Well, these are all provisions which require a detailed session. But I am only telling you the bar created by various provisions of CPC. Let us have a look at Order 22 Rule 9. After 22 Rule 9, where a suit abates or is dismissed under this order, no fresh suit shall be brought at the same cause of action. What then is the remedy of the plaintiff? he has to make an application for setting aside the abatement under Order 22, Rule 9, Sub-Rule 2, within 60 days from the date of abatement. If that is not done, then the provision itself says that an application under Section 5 of the Limitation Act. The next bar that is created is by Order 23, Rule 1, Sub-Rule 4. Now, Order 23, the title is Withdrawal and Adjustment of Suits. Adjustment is a kind of compromise. Now, there are two kinds of withdrawals. Withdrawal simpliciter and withdrawal with liberty to file a fresh suit in respect of the same subject matter. We usually say in respect of the same cause of action. No, the language employed by CPC is in respect of the same subject matter. Order 23, Rule 1 provides for withdrawal simpliciter, simply withdrawing the suit. Then withdrawing the suit with liberty to file a fresh suit. This withdrawal simpliciter is technically, as per the language of the CPC, is called abandonment of the suit. It is abandonment. In fact, this provision, Order 23, Rule 1, was amended when CPC was substantially amended in 1976. Before that, the word used was withdrawal itself. I usually tell the word withdrawal itself was withdrawn by 1976 amendment, and that word was also abandoned. Now the word used is abandonment. Anyway, we usually say it as withdrawal. Now, what is the effect of withdrawing a suit, that is withdrawal simpliciter, and what is the effect of withdrawing a suit without seeking liberty to file a fresh suit when a fresh suit is barred, when a fresh suit is filed? Let us read it. Sub-Rule 4 of Order 23, Rule 1 provides for it. Where the plaintiff A abandons any suit or part of a claim under Sub-Rule 1, or withdraws from a suit or a part of a claim without the permission of the court referred to in Sub-Rule 3, what is the consequence? He shall be liable for such costs as the court may award, and shall be precluded from instituting any fresh suit in respect of such subject matter or such part of the claim. Therefore, lawyers should be very careful. If you are withdrawing the suit, your fate is sealed once for all. Rather, your client's fate is sealed. If it is withdrawal with liberty to file a fresh suit, certainly it is a discretion of the court. If liberty is given, a fresh suit can be barred. Of course, it is subject to limitation. Then, if without seeking that withdrawal, if you get the suit dismissed, you can't bring a fresh suit. Then, the next bar is created by Order 23, Rule 3A, 3 capital A CPC. No suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful. This is an insertion by the 1976 amendment. A suit does not lie for challenging the compromise decree. So these are some provisions. Then we have certain provisions relating to execution, which also bar a suit. Let us go to Section 47 CPC. Section 47 says, all questions relating to execution, discharge, or satisfaction of a decree shall be decided by the court executing the decree and not by a separate suit. So questions relating to execution of the decree. Is the decree executable? Or has it already been executed? Is there excess execution? Discharge of the decree. We have some statutes which have the effect of discharging a decree. We have, for example, the Karnataka Debt Relief Act of 2018. If a person who is defined as a debtor under that act approaches even the executing court saying that I am a debtor as defined under this act, the decree stands discharged. If he is in civil prison, he has to be let off. If his property is attached, the attachment has to be raised. Several consequences are provided. That is called discharge of the decree, or for some other reason. Satisfaction of the decree. Well, I have already satisfied the decree. I was required to pay money, I have paid the money. I was required to execute a document pursuant to a decree for specific performance, I have done it. I was required to demolish an unauthorized construction pursuant to a decree for mandatory injunction, I have done it. There is a decree for eviction, I have vacated the property. So decree is fully satisfied. These are questions which the executing court will alone have to decide and not a separate suit. Order 21, Rule 58, Sub-Rule 2. Now, when a property is attached in execution of a decree for money, then a person can file a claim petition saying, well, the property belongs to me, that could not have been attached. Or he may make an objection on the ground that the property is not liable to attachment at all in your section 60 CPC. So the executing court itself will have to decide that question. Please go to subrule 2 of Order 21 Rule 58. All questions, including questions relating to right, title, or interest in the property attached, stating that the property belongs to the judgment debtor, the decree holder has brought the property for attachment, the court has attached. Some person may say, well, the property does not belong to the judgment debtor at all. It is my property. I am not liable to pay any money to the plaintiff decree holder. My property is attached. Please adjudicate whether I have got title to it, right to it. So all questions related to right, title, or interest in the property attached arising between the parties to a proceeding are the representatives under this rule and relevant to the adjudication of the claim or objection shall be determined by the court dealing with the claim or objection and not by a separate suit. Then lastly, there is one more bar created by CPC, that is Order 21 Rule 101. Now, when there is a decree for eviction or decree for possession, some person who is not bound by the decree, if he causes obstruction in the execution of the decree, then the decree holder can file an application under Order 21 Rule 97. Some person other than the judgment debtor is dispossessed while executing a decree, a third person who has an independent title, he can make an application under 21 Rule 99. Those applications are adjudicated under 21 Rule 98 and Rule 100. And what are those questions? Please go to Rule 101. All questions, including questions relating to right, title, or interest in the property arising between the parties to a proceeding, or an application under Rule 97 or 99, or the representatives relevant to the adjudication of the application shall be determined by the court dealing with the application and not by a separate suit. So these are the bars created by CPC itself. Then Section 9 CPC speaks of two other bars. One is their cognizance is either expressly or impliedly barred. So if a specific statute creates an express bar saying no suit shall lie, it is an express bar. But a particular statute may not contain a specific provision saying a suit will not lie. But when we examine the scheme of the Act, it gives an indication that there is an implied bar. There are a number of statutes. I might not have also noticed them. Whatever provisions, whatever statutes which I have come across, I am only referring to them. As and when a case comes up, you are required to file wakalat, you can examine that. I am only telling you a few enactments which as lawyers practicing in the civil side need to keep in view. First, let us refer to some express bar created by specific statutes. One, the Family Courts Act. The bar is created by Section 8 of the Family Courts Act. Exclusion of jurisdiction and pending proceedings. Where a family court has been established for any area, no district court or any subordinate civil court referred to in subsection 1 of section 7 shall, in relation to such area, have or exercise any jurisdiction in respect of any suit or proceeding of the nature referred to in the explanation to that subsection. Which are the matters over which a family court has got jurisdiction? That is contained in section 7 of the Family Courts Act, section 7, subsection 1. Subject to the other provisions of this Act, a family court shall have A to G. I am not reading it because I am not dealing with Family Courts Act as such today. Section 7(1) A to G, they give a list of matters over which the family court has got jurisdiction. What does section 8 say? If a family court has been established for that area, The usual civil court does not have jurisdiction. This is a specific bar created by section 8A. Then what is the consequence? See subsection C, 8C. Every suit or proceeding of the nature referred to in the explanation to subsection 1 of 7 and every proceeding under chapter 9 CRPC, that is 125, which is pending immediately before the establishment of such family court before any district court or subordinate court referred to in that subsection or as the case may be before any magistrate in the said court, which would have been required to be instituted or taken before or by such family court, if before the date on which such suit or proceeding was instituted or taken, this act had come into force and such family court had been established, shall stand transferred to such family court on the date on which it is established. In Karnataka, there is a pattern. Some family courts have got jurisdiction over the entire district. Some family courts have got jurisdiction only over the district headquarters. Now, let us take a particular district where the jurisdiction of the family court is confined only to the district headquarters. There is a matter outside the district headquarters in the court of the senior civil judge, a petition for restitution of conjugal rights or judicial separation, nullity of marriage or divorce is filed. It has already been filed yesterday or day before. Today or tomorrow, a family court is established covering that taluk also. Or it says the family court which is situated in the district headquarters shall hereafterwards have jurisdiction over this area also. What is its effect? The suit pending in the court, the petition pending in the court of the senior civil judge is statutorily transferred. It gets automatically transferred. This is a jurisdiction created by, a bar created by section 8 of the Family Courts Act. I have something more to say about it. At the end, after some time more, I will tell something about this family courts only to highlight what is the effect of a decree passed by a court which doesn't have inherent jurisdiction or jurisdiction over the subject matter of the suit. The next is section 6 of the Commercial Courts Act. There can absolutely be no dispute that a family matter is a civil dispute. A commercial dispute is also a civil dispute. Let us see what section 6 of the Commercial Courts Act says. Jurisdiction of commercial court. The commercial court shall have jurisdiction to try all suits and applications relating to a commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested territorial jurisdiction. So in Bangalore, we have families, commercial courts, some 6, 7 or 8 for the Bangalore urban, 1 or 2 for Bangalore rural, and in other places, either the principal district judge or additional district judge has been notified as commercial court. So if it is a commercial dispute, what a commercial dispute is, it is defined in section 2C of the commercial 2(1)(c) of the Commercial Courts Act. What is a specified value is defined in section 2(1)(i). How to determine that specified value is provided by section 12. If these things are satisfied, that the commercial court alone will have jurisdiction, the regular civil court will not have jurisdiction. Here, section 11 also bears a reference. Bar of jurisdiction of commercial courts and commercial divisions. Notwithstanding anything contained in this act, a commercial court or a commercial division shall not entertain or decide any suit, application, or proceeding relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or impliedly barred under any other law. Now, here again, it makes the indirect reference to section 9. So, section 9 says if the jurisdiction of a civil court is either expressly or impliedly barred under any law, then though it's a dispute of a civil nature, civil court cannot entertain it. So, if it is similarly that bar applies to the Commercial Courts Act, if the civil court cannot entertain the suit on account of a bar created, specific bar or implied bar created by any other statute, the commercial court also cannot entertain it. Then section 15(2) of the Commercial Courts Act also bears a reference. Transfer of pending cases 15. All suits and applications, including applications under the Arbitration and Commercial Conciliation Act, relating to a commercial dispute of a specified value pending in any civil court in any district or area in respect of which a commercial court has been constituted, shall be transferred to such commercial court. So this is a bar created with Commercial Courts Act. Here itself, one clarification is required in respect of Section 8 of the Arbitration and Conciliation Act. Now, what is Section 8? Section 8, subsection 1 of the Arbitration and Conciliation Act. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later on the date of submitting his first statement of the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Section 8 is not a total bar for this suit. Now, if there is an arbitration agreement or if there is an arbitration clause in an agreement, certainly the plaintiff who has filed the suit should have resorted to arbitration. Either not knowing the existence of the arbitration clause or he not having been properly given legal advice or deliberately he brings a civil suit in a civil court. Or he has some idea that it is, though there is an arbitration clause, the dispute itself is not arbitrable, some advice has been given or whatever it is. He brings a civil suit. Here, the defendant, before he files his written statement, should make an application under Section 8 saying, see, there is this arbitration clause, therefore, the matter has to be referred to arbitration. It is not a bar as such regarding jurisdiction. If the defendant does not make that application within the time provided there and complying with other formalities, then the civil suit would continue. So this also has to be kept in view of jurisdiction. Next, we have the Recovery of Debts and Bankruptcy Act of 1993, popularly called as this DRT Act and other things. This has also created certain bars for the maintainability of a civil action in a civil court. One of those sections is 18, 17, first section 17. Of course, I'm not very familiar with this enactment, but only for today's purpose, I am just drawing your attention to a few provisions here and there. Section 17 of this Recovery of Debts and Bankruptcy Act. A tribunal shall exercise, that is Debt Recovery Tribunal, DRT, on and from the appointed day, the jurisdiction and powers and authority to entertain and decide applications from the banks and financial institutions for recovery of debts due to such banks. 18. On and from the appointed day, no court or other statutory authority shall have or to be entitled to exercise any jurisdiction, power, or authority except the Supreme Court and the High Court exercising jurisdiction under Articles 226 and 227 in relation to the matter specified in Section 7. Then we have Section 31 of that Act. Every suit or other proceeding pending before any court immediately before the date of establishment of a tribunal under this Act, being a suit or proceeding, the cause of action wherein it is based is such that it would have been if it had arisen after such establishment within the jurisdiction of such tribunal, shall stand transferred on that day to such tribunal. Then we have the Surface Act. It is a very long enactment, a long title. Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Long back, we had one act called Taluk Panchayats, Nayab Panchayats, Mandal Panchayats, some Jilla Parishad Act of so and so. Usually in judgments, when an act is referred for short, TP Act for short, Potsdam Act like this, the Honorable Judge said, this Act really requires a sharp title. According to me, the securitization, reconstruction of financial, that is why usually it is called the Surface Act. Let us refer to section 34 of this Act. 34 of the Surface Act. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debts recovery tribunal or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted, etc. The next bar that is required to be noticed by lawyers practicing in the civil side is the Karnataka Land Revenue Act, Section 61, 62, and 63. 61 of the Land Revenue Act says, which are the matters which are within the exclusive jurisdiction of the revenue courts and which are the matters which are barred by the civil courts. I am not dealing with it. I am only drawing the attention of the participants to tell that Section 61 of the Karnataka Land Revenue Act contains certain provisions, refers to certain matters in respect of which only the revenue court has exclusive jurisdiction and the jurisdiction of the civil court is barred. It is a clear case of express form. Then Section 62 says, whatever might have been stated, it is an exception to Section 61. Whatever might have been stated in Section 61 in respect of matters provided by Section 62A, B, and C, a civil suit would like. Then the next section is Section 63. Section 63 says, if the Land Revenue Act itself has provided for a mechanism, appeals, revisions, and all that, without exhausting those remedies, a civil suit will not claim. These are certain provisions of the Karnataka Land Revenue Act, which the participants may remember. Then we have Section 133 of the Karnataka Land Reforms Act. Notwithstanding anything in any law for the time being in force, no civil or criminal court or officer or authority shall in any suit, case, or proceeding concerning a land decide the question whether such land is or is not agricultural land and whether the person claiming to be in possession is or is not a tenant of the suit land from prior to 1/3/1974. If cut-off date is 1/3/1974, if prior to that, whether he was a tenant or not, whether the land is an agricultural land or not, is a matter to be decided by the land tribunal. And there is also a provision which says that the proceedings before the civil court need to be stayed till the dispute is resolved by the Land Reforms Tribunal. Then we have the Karnataka Cooperative Societies Act. Notwithstanding anything contained in any law for the time being in force, if any dispute touching the constitution, management, or the business of a cooperative society arises among members, past members, and persons claiming, a big list is given. So that dispute shall be referred to the registrar for decision, and no civil or labor or revenue court shall have jurisdiction to entertain any suit or other proceeding. So this is some of these parts. Then we have this implied bar. We have this Karnataka Rent Act. You may in this regard make a note of a decision. 2012, Volume 4, Karnataka Law Journal 402. Since it is an implied bar, obviously based on case law only we'll be able to understand this. 2012, 4 KLJ 402. Ananta Swami versus Radha Srinath. Ananta Swami versus Radha Srinath. Now, for those who are a little familiar with the Karnataka Rent Act, it is easy to understand. For the novice, it may be a little difficult. You see, under the Transfer of Property Act, a lease is determined in several ways. When a lease comes to an end by whatever means provided by whatever mode provided by Section 111 of the Transfer of Property Act, the lessor, whom we popularly called as the landlord, can file a civil suit against the tenant. That is the popular word. Transfer of Property Act uses the word lessee for eviction. But there are certain premises covered by the Karnataka Rent Act 1999. Earlier, we had the Karnataka Rent Control Act 1961. Before that, the Mysore House Rent Control and Accommodation Act. So now we have the Karnataka Rent Act of 1999. Section 27 says, notwithstanding anything contained in any law and all that. Now, this is a rent legislation essentially meant for the protection of tenant. Though under the Transfer of Property Act, the lessor or the landlord can seek eviction if the lease is terminated by any of the modes covered by Section 111. If the demised premises, the premises let out, or the subject matter of the lease is something covered by the Karnataka Rent Act, then only by filing a petition under 27, 28, there are various provisions in the Karnataka Rent Act, a landlord can get an eviction order. A civil suit does not lie. In this decision, it has been specifically observed by Honorable Justice S. Abdul Nazir, when he was a judge of the Karnataka High Court, that this Karnataka Rent Act creates an implied bar for a civil suit. What is the consequence of a civil suit being filed when the Karnataka Rent Act was applicable to that case is something which I am going to tell a little later. Please wait. Then we have the Industrial Disputes Act. There is no specific provision in the Industrial Disputes Act which bars the jurisdiction of a civil court from deciding a dispute between a workman and an employer. But decisions say that the jurisdiction of the civil court is impliedly barred. We have got number of decisions. Most of them have been referred to in 2021, Volume 10 SCC 752. 2021, Volume 10 SCC 752, Milky Ram versus Himachal Pradesh State Electricity Board, 2021, 10 SCC. In fact, my own knowledge of the Industrial Disputes Act and labor disputes is very limited. But I only know that the Industrial Disputes Act impliedly bars the jurisdiction of civil courts in respect of disputes which a labor court or the industrial tribunal can decide under that act. This is a case of implied bar. Then we have number of enactments relating to local bodies. Gram Swaraj Act, then this Karnataka Municipalities Act, Karnataka Corporations Act, BBMP Act. Now, from 15th May, we will have this Greater Bangalore Act, something of this kind. Now, a detailed examination of those provisions is required. If there is a provision for appeal or approaching the standing committee and other things, a civil suit would be barred. Well, there are all situations when a particular case comes up, you are required to appear for the plaintiff or for the defendant, file a suit, then go through those enactments. Then only you decide whether a civil suit lies or not. Now, in that regard, we have a judgment of the Supreme Court in 1993, Volume 1, SCC 161. 1993, Volume 3, SCC 161. Shivkumar Chada, CHA. Shivkumar Chada versus Municipal Corporation of Delhi. 1993, 3 SCC 161. Well, this decision refers to good number of earlier decisions with regard to Section 9 CPC, Industrial Disputes Act, various other enactments. Please read it. Now, one basic thing, now a few decisions only and a few basic things which lawyers practicing on the civil sides need to know. I started telling a mechanical way of putting in the written statement that the suit is not maintainable in law and fact. This court has no jurisdiction. Your written statement should specifically tell whether there is a territorial jurisdiction the court lacks, or the pecuniary jurisdiction the court lacks, or jurisdiction over the subject matter. If it is jurisdiction over the subject matter, which is that law which bars the suit? Is it the Land Revenue Act, Land Reforms Act, Rent Act, Surface Act, whichever enactment is? There must be a specific plea in that regard. The reason is the law is in this regard. No authority is required for the proposition that a suit of a civil nature lies in a civil court. Section 9 itself provides for it. No authority is required. Plaintiff need not establish that the suit lies. Of course, if the court itself finds an initial bar for entertaining the suit, certainly the plaintiff has to satisfy the court even at the time of registration of the suit. Well, in view of a special enactment, does the suit lie? But when once the court entertains that suit and the defendant says suit is barred, it is for the defendant to satisfy the court. I am not saying whether the defendant proves no. Whether the contention of the defendant that the suit is barred under this act, under this provision, is sustainable. That is how the issue needs to be framed. Therefore, the legal position has been very clear in this regard that no authority is required for the proposition that a civil court has got jurisdiction to entertain a civil dispute. Exception is this. Is there an implied bar or an express bar or any bar created by the Civil Procedure Code? In fact, I have heard people telling the civil court should jealously guard their jurisdiction. If the courts themselves do not guard their jurisdiction, who else will guard it? And I add, they should be zealous in guarding it. Jealously and zealously guard their jurisdiction. No authority is required for the proposition that the jurisdiction, that a civil court has got jurisdiction. It is for the defendant to satisfy the court as to why this suit does not lie in the civil court. It is a dispute of a civil nature, but yet the civil court lacks jurisdiction because of a bar created by CPC itself, or an express bar created by a statute, or an implied bar that could be inferred. This is the basic thing. We have got good number of decisions, but any presentation on Section 9 CPC would be incomplete without a reference to the decision of a constitution bench, a celebrated decision in the famous Dhulabai versus State of Madhya Pradesh. Dhulabai versus State of Madhya Pradesh, AR 1969 Supreme Court 78. Any commentary on CPC or any decision on Section 9 CPC would invariably make a reference to this Dhulabai. It is a celebrated decision. It's a constitution bench because the division bench itself referred the matter to a constitution bench because it said there were different views in this regard. Now, Honorable Justice M. Hidayatullah, writing for the bench, has dealt exhaustively with regard to the jurisdiction of the civil courts. This decision is really an eye-opener. In fact, this for recovery of tax said to have been illegally realized by the state of Madhya Pradesh. Our first impression would be there will be some remedy under that enactment, tax enactment, sales tax or whatever it is. Ultimately, the court says the court had jurisdiction to deal with that matter. A detailed discussion is made in this regard. The legal position is summed up in para 35. The result of this inquiry into the diverse views expressed in this court may be stated as follows. Number one, where the statute gives a finality to the orders of the special tribunals, the civil court's jurisdiction must be held to be excluded if there is adequate remedy to do what the civil courts would normally do in a suit. For example, the Karnataka Land Revenue Act. I have drawn your attention to section 61, which are the matters which are exclusively within the jurisdiction of the Land Revenue Court, and which are the matters of which the civil court's jurisdiction is excluded. Which are the matters in respect of which the jurisdiction of the civil court is saved? That is contained by section 62. 63 says, if there is a machinery provided under that act for the aggrieved person to remedy his grievance, then the suit is barred. He has to exhaust that remedy. So now we will have to see. Now, for example, under this Land Revenue Act itself, against an order passed by the Tahsildar, an appeal lies to the Assistant Commissioner, then a revision to the Deputy Commissioner, then to the Appellate Tribunal. So a remedy is provided under the Act itself. Therefore, there is a clear bar. The remedy may be insufficient. Industrial Disputes Act, well, there will be some attempted conciliation. Thereafter, the matter is referred to the labor court or industrial tribunal, depending upon the nature of dispute. Machinery is provided there. Therefore, they are all implied bars. Adequate remedy is provided under the enactment. An appeal is provided against an act or an order passed by a statutory authority. If that is then there is either an implied bar or an express bar. Then, such provision, however, does not exclude those cases where the provisions of the particular act have not been complied with, or the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure. This is very, very important. No doubt a particular enactment bars the jurisdiction of a civil court. An authority is created under that act to decide the dispute. But that authority, while exercising the jurisdiction under that act, does not comply with the provisions of the act itself. The act has created some procedure. It has created some mechanism. It has provided for a detailed procedure and inquiry. The authority does not follow that at all. Now, number of cases during the 80s and 70s, land reforms tribunals were constituted. The jurisdiction of the civil court is barred. But the land reforms tribunals, they were not acting in accordance with law. They were not following the principles of natural justice. Therefore, the remedy of the aggrieved person was to file a writ petition before the Honorable High Court. The Honorable High Court also could not completely settle the dispute. It would remand the matter to the tribunal to have a relook into it following the procedure. Then for some time, we had the appellate tribunal presided over by a senior civil judge that was also abolished. So therefore, this decision says where an authority under the act does not follow the provisions of that act itself, or does not follow the principles of natural justice or fundamental principles of judicial procedure, then the civil court's jurisdiction is not barred. Of course, whether sufficient remedies are available, some 6 to 7 factors have been enumerated in this decision to examine whether the jurisdiction of a civil court is either impliedly barred or expressly barred. Then we have a judgment of the Karnataka High Court by Honorable Justice, is a division bench judgment authored by Honorable Justice M.N. Venkatachalaya when he was a judge of the Karnataka High Court. Karnataka Bank versus Narayana Bhatta. Karnataka Bank versus Narayana Bhatta. ILR 1986, Karnataka 1887. ILR 1986, Karnataka 1887. In the year 1976, an act was promulgated, was brought into force by the Karnataka State Legislature called the Karnataka Contract Carriages Act. This Narayan Bhatta had availed some loan from Karnataka Bank for purchasing a vehicle. So a suit had been filed for recovery of the loan advanced to Narayan Bhatta. Narayan Bhatta contended that this Karnataka Contract Carriages Acquisition Act, which has even acquired his vehicle, bars the jurisdiction of a civil court. Ultimately, the matter reached the Honorable High Court. A division bench said a close examination of that act would indicate that there is no bar for the bank to file a suit for recovery of money lent. Now, a number of English decisions and judgments of the Supreme Court have been referred to in this judgment. But one para I want to refer to in the statement. The legislative technique, please see the beauty of these expressions. The legislative technique of exclusion of jurisdiction of courts follows the familiar pattern. No civil court shall hereafter entertain, notwithstanding anything contained in any law. No civil court shall entertain any suit, no injunction. It follows a familiar pattern. Legislature has two favorite techniques to exclude or reduce interference by courts. One is excluding the jurisdiction or reducing interference by the courts. One is the indirect method of conferring power couched in wide and subjective language so that even if the courts have jurisdiction, there is not much scope for interference. Civil court has got jurisdiction, but not much scope for interference. This is the indirect method. The direct method is by enacting an express exclusion of civil court's jurisdiction. But the courts, it is said, are not to be disarmed so easily. Now, there is one other principle. Defendant says this court has no jurisdiction for XYZ reasons. Whether the court has got jurisdiction to decide whether it has got jurisdiction, certainly it has got jurisdiction. In this arbitration law, we have this principle of competence. The arbitral tribunal has competence to decide whether it has competence to decide this matter, whether it is competent to decide this matter. Competence. Same thing. So civil court has got jurisdiction to decide whether it has got jurisdiction. Defendant says they have no jurisdiction. Unless the civil court decides whether it has got jurisdiction or not, it can't do it. Therefore, it has got jurisdiction to decide whether it has got jurisdiction or not. This is, as I said, in this arbitration law called as competence rule. The present inquiry is as to matters over which the Act confers exclusive jurisdiction on the authorities under this Act and correspondingly takes away the jurisdiction of the civil court. As I said, section 61 and 62 of the Land Revenue Act. To ascertain the area of operation of this preclusive clause, that is precluded, civil court's jurisdiction is precluded, the scope of the tribunal's statutory jurisdiction must first precisely be identified and the tribunal confined within the limits of its own powers. What is excluded from the civil court's purview must necessarily correspond to what falls within the tribunal's exclusive jurisdiction. I have been repeatedly referring to the Land Revenue Act. 61 says these are the matters in respect of which the Land Revenue Court has exclusive jurisdiction. These are the matters in respect of which the jurisdiction of the civil court is completely excluded. 62 saves the jurisdiction of the civil court. But courts have always the jurisdiction to examine whether what purports to be a statutory decision to which finality is statutorily intended is after all no decision at all and is a nullity. As held in the other decision in this Dhruvubai case, if the tribunal or the authority under the Act has not followed principles of natural justice, has not followed the provisions of the Act itself, it is a nullity. No amount of legislative fortifications of the authority and finality of the tribunal's decision can protect a nullity. The finality of a statutory decision or adjudication can also be unsettled in a civil court if the tribunal had not followed the fundamental principles of judicial procedure or the decision is otherwise vitiated by factors which in law render the decision infirm. So now, practically with this, I have finished section 9 CPC. But a few things I need to tell, otherwise the session would be incomplete. We have seen from a reading of section 9 CPC that CPC itself contains certain provisions which bar a fresh suit, though it is a suit of a civil nature. Section 9 says if there is an express bar created by a statute, the jurisdiction is barred. I have referred to a few enactments. The jurisdiction of the civil court is barred if there is an implied bar created by some statute. You need to refer to a few decisions. This is clear. Now, rightly or wrongly, a civil court, an ordinary civil court, exercises jurisdiction when it lacked initial jurisdiction, inherent jurisdiction, or jurisdiction over the subject matter of the suit. Either the provisions of the particular enactment are not brought to the notice of the court, or the the existence of another statute which barred the jurisdiction of the court, or deliberately he brings an action in a civil court. Defendant also deliberately may think, why go to some authority under some enactment? Let me have a decision in the hands of the civil court. Or he may not be aware of the existence of a particular statute which creates an express bar, a implied bar. So the court has not noticed it. Attention of the court is not drawn to it. Jurisdiction is wrongly exercised by the court. What is its consequence? Please be very, very clear in this regard. If it is a question of territorial jurisdiction or pecuniary jurisdiction, the judgment or decree is not a nullity at all. It is very clear. I am giving the decisions in this regard. If a civil court entertains a suit for want of, even though it had no territorial jurisdiction, or entertains a suit if it had no pecuniary jurisdiction, if the defendant does not raise that at or before the time when the issues are settled, he cannot later raise it, and the appellate court also cannot reverse the judgment of the trial court only on the ground that it lacked territorial or pecuniary jurisdiction. This is clear from sections 21 subsection 1 and 21 subsection 2 CPC. Exception is some injustice is caused by the court exercising jurisdiction, territorial jurisdiction or pecuniary. Such situations are very rare. That has been made clear. But if there is no jurisdiction or the subject matter of the suit, there is lack of inherent jurisdiction, then even if the decree is confirmed by the highest court in the land, that decree is a nullity. It goes to the root of the matter. That it is a nullity, it is liable to be ignored. It need not be challenged by way of an appeal. As and when an occasion arises, its nullity can be raised. The legal position is, during execution proceedings, there can be an attack on the decree on the ground that it is a nullity. It is a void decree. It has been passed by a court which had no inherent jurisdiction or jurisdiction over the subject matter of the suit. There can also be a collateral attack. I will explain what this collateral attack a little later. Please make a note of these important decisions. AR 1954 Supreme Court 340. AR 1954 Supreme Court 340. Karan Singh versus Chaman Pasha. Karan Singh versus Chaman Pasha. There are a number of decisions in between, but I am not troubling you with all of them. I am referring to a later one. 2019, Volume 3 SCC 594. 2019, Volume 3 SCC 594. Snehalata Goyal versus Pushpalata. Snehalata Goyal versus Pushpalata. What these two decisions have said is, lack of territorial or pecuniary jurisdiction, such pleas are only technical. A superior court will not entertain it. Of course, exception is provided by 21.1 and 21.2. Very rarely those exceptions are attracted. But lack of inherent jurisdiction or jurisdiction of the subject matter issue goes to the root of the matter. There can be an attack on the decree during the execution, and there can also be a collateral attack. What is that void decree? A nullity. In that regard, you may refer to a latest decision in 2024, Volume 4 SCC 696. 2024, Volume 4 SCC 696. Asma Latif versus Shabir Ahmad, 2024, Volume 4, SCC 696. Asma Latif and Shabir Ahmad. You may read paras 23, 38, 39, 46, 47, and 49 of this decision. Now, attack during execution proceedings. I already referred to section 47 CPC. All questions relating to execution, discharge, or satisfaction of a decree shall be decided by the executing court and not by a separate suit. There are some two explanations. All that is not necessary for the present. Now, let us go to the Land Revenue Act. We have seen the Land Revenue Act confers exclusive jurisdiction on a revenue court in respect of certain matters, specifically excludes the jurisdiction of civil court in respect of those matters. A civil suit is entertained by a civil court in respect of a matter over which exclusive jurisdiction lies with the revenue court. Jurisdiction is excluded by the civil court. A decree is passed. Defendant need not challenge the decree at all. He can keep quiet because it is a void decree. It is a nullity. It is a different matter. He may file an appeal, get it reversed. Even if he does not do it, even if the appeal is dismissed, certainly it's a void decree. It is confirmed by the highest court. So during execution, that can be raised. Land Reforms Act. Whether the land is an agricultural land or not, whether so-and-so is a tenant or not, is within the exclusive domain of the land tribunal. Civil court decides it. Plaintiff was a tenant, defendant was a tenant, he was not a tenant, it was an agricultural land, not an agricultural land. It is of no consequence. Even in the execution side, that can be done. There is what is known as error in jurisdiction and error of jurisdiction. Error of jurisdiction means court did not have jurisdiction at all. If the court did not have jurisdiction at all, I am again telling not territorial or pecuniary, only inherent jurisdiction or jurisdiction over the subject matter of the suit, then it is a total error. The judgment is a nullity that need not be challenged by way of an appeal or revision. The aggrieved person can keep quiet, attack the decree when it is put in execution, or there is a collateral attack. I will tell what that collateral attack a little later. But error within the jurisdiction, the court had jurisdiction, but it committed some error, factual error. So suit was barred by limitation. It did not notice it. Evidence was not thoroughly appreciated. Then, if the decree is not challenged by way of an appeal or revision, then the decree becomes final. During execution proceedings, the defendant or the judgment debtor cannot say that the decree is a nullity, suit was barred by it, because the fundamental principle is the executing court cannot go behind the decree. He has to challenge it. If it is an error within the jurisdiction, court had jurisdiction, but it committed an error that can be rectified only by a superior court. Court had no jurisdiction at all. Well, the defendant can ignore it. True, you have obtained a decree. Which court has given the decree? The court has been given by a decree has been given by a court which was not competent to grant it. I am liable, I am entitled to ignore it. I will attack it as and when the matter reaches the appropriate forum. Now, we have number of decisions in respect of these rent control legislations. I am not troubling you with all of them. You can search it by yourself. Now, as I told you, Karnataka Rent Act 77 and other provisions, our High Court has said they had an implied bar for a civil suit to be entertained for eviction. Let us say, on a particular day, in a particular place, a suit is filed for eviction, a regular suit. The tenancy is terminated either by issue of a notice, quick notice, or express of time, or whatever it is. The court is not aware of the fact that the premises is covered by the Karnataka Rent Act. Plaintiff is not aware, defendant is not aware, or though are aware, defendant may anyway allow the court to proceed. Anyway, I can challenge it during execution. Deliberately also I may do it. Ultimately, the decree for eviction passed by the civil court is confirmed even by the highest court of the land. It is a nullity. The defendant judgment debtor, when this decree is put for execution, can point out to the court, well, there is a decree for eviction. It is true that this decree is confirmed by the highest court, but it is still a nullity. I can challenge it. Or he might not have preferred an appeal. True, I have not preferred an appeal. Why I did not prefer an appeal? I can bring it, challenge it during the course of execution. There can be an attack on a decree which is a nullity during execution proceedings. And what is this collateral attack? Now, a decree can be challenged in the usual course by way of an appeal. There is a direct way of attacking a decree. If an act provides for a revision, well, file a revision, attack the decree. Or in some situations, a suit can also be filed for challenging the decree. I will tell you when that suit lies later. It can be an appeal, it can be by way of a suit also. That is also not done. They are the direct ways of attacking a decree. I usually tell we have some particular disease. We go to a doctor. Treatment is specifically given to it. It's a direct attack on the disease. But when the doctor examines us, or when it is a case of surgery, he sees something else also. He sees something else also. The patient has not gone to him for that particular ailment or something found there. Or even by physical examination or by scanning or by X-ray examination, he finds something. That can also be cured. There it's a collateral thing. I go there for stomachache, I go there for some headache. But the doctor finds something else in me that can also be done. That could be done. So therefore, it's a collateral attack. What is this? Now let me go to this family courts. It's precisely a matter of some concern. Please hear me very carefully. Let us say a family court is established in a particular place. Let us say it has got jurisdiction over the entire district. Some miscommunication, or earlier it had jurisdiction only over the district headquarters. Now the jurisdiction is extended, let us say, over the entire district. Not coming to know that the jurisdiction is extended over the entire district. A petition has already been filed, it is continued, it is not transferred to the newly established family court, or deliberately it has gone in the senior civil judges court. A decree for divorce is passed. I am not even telling an ex parte decree, please understand this. Husband had filed a petition for divorce. Well, wife remained ex parte decree. Or the wife seriously contested. The court granted a decree for divorce in favor of the husband. The wife does not challenge the decree at all if it is Hindu Marriage Act 29 or so by way of appeal, Special Marriage Act, some other provision. The wife does not challenge it by way of an appeal. A lawyer advises her, don't challenge it. I have another thing, I have a remedy, I have found out a relief for this. Or for some reason, some poor woman, she doesn't know what is required to be done, she keeps quiet, leave it. Now, she files a suit for maintenance. There is a decree for divorce against her, passed by a court. She files a suit for maintenance. The husband in the written statement says it is true that the plaintiff was my wife, but there is a decree of divorce passed in MC so and so by the senior civil judge at a particular place. She is no longer my wife. I am not liable to provide maintenance. Well, this defendant lawyer asked the plaintiff, well, no. Did you challenge this by way of an appeal? No. Court says, why did you not challenge? No, I am not liable to, I am not required to challenge it. Because a decree which is a nullity. Even though there is a decree for divorce, which is that court which has granted, a court which had no jurisdiction. Because as on the date of the decree, a family court had been established for that area, Section 8 requires it. I am giving you an extreme situation. Certainly the suit is maintainable. Or there is a decree for divorce obtained at the hands of a court which had no jurisdiction, senior civil judge. The wife files a petition for restitution of conjugal rights, or it might happen. Wife might have obtained a decree for divorce against the husband from a court which had no jurisdiction at all. Husband files a petition for restitution. Well, there is already a decree for divorce. No, all right, there is a decree. I don't dispute it. I have not challenged it by way of an appeal. I challenged it. Appeal is dismissed on some reason, for some ground. But did the court have inherent jurisdiction? This is called collateral attack. In some other proceeding, she doesn't seek a declaration that the decree passed for divorce in MC so and so is a nullity. It is void. She need not seek a declaration. That will be a direct attack. She seeks some other relief. It's a collateral proceeding. There also, this nullity can be questioned. These are certain basic things. Now, what is a decree? What is the effect of a decree which is granted by a court which lacked inherent jurisdiction or jurisdiction over the subject matter of the suit? It is a nullity. It is a void decree. In technical language, it is called quorum non judice. QORAM quorum non judice. NONJUDICE. Now, this Black's Law Dictionary gives the meaning of the word quorum non judice. Quorum judice first. Quorum judice in the presence of a judge. Quorum non judice, it is a Latin expression, not before a judge. Outside the presence of a judge. Certainly a senior civil judge who is a judicial officer has rendered the judgment. A civil court has entertained a suit in respect of an industrial dispute. He is certainly a judge. But the effect of the judgment is as though the judgment is given by a non-judge. It is as though the proceedings have taken not before a judge. Though he is appointed as a judge, he was not competent to give that judgment. Therefore, outside the presence of a judge, before a judge or court that is not the proper one, or that cannot take legal cognizance of the matter. It is called quorum non judice. So the judgment is a nullity. I am repeating, if it is lack of territorial or pecuniary jurisdiction, certainly the judgment is not a nullity. Read 21.1 and 21.2 CPC. Also read section 51 of the Karnataka Court Fees and Suits Valuation Act in the light of section 99 CPC and Kiran Singh versus Tamal Pasha, you will understand that. But in this context, please go to section 44 of the Evidence Act corresponding to section 39 of the 38 of the Bharatiya Sastya Adhiniyama. Let us have a look at section 44 of the Evidence Act. I don't read the Bharatiya Sastya Adhiniyama, verbatim similar 38 of Indian Evidence Act corresponds to 38 of Bharatiya Sastya Adhiniyama. Now, sections 40 to 44 of the Indian Evidence Act come under this heading, judgments of courts of justice when relevant. Section 40 says, if there is already a previous judgment, it bars it's a relevant fact. There is already a judgment. Therefore, this suit doesn't lie. It is based on the principle of res judicata contained in section 11, or on the criminal side, attrifies acquit, attrifies convict, covered by section 300 CRPC, double jeopardy. That's it. Because I am already prosecuted, I am acquitted or convicted. Now a second prosecution does not lie against me. I produce the certified copy of the previous judgment. Or a suit had already been filed by me. I have obtained a degree. A defendant again files another suit. Well, it is barred by the previous suit is a relevant fact to establish that the second suit does not lie. 41, no need. 42 and 43 are not required for us. 44. Fraud or collusion in obtaining judgment or incompetency of the court may be proved. Same thing as 38 of BSC. Any party to a suit or other proceeding may show that any judgment, order, or decree which is relevant under 40, 41, or 42, and which has been proved by the adverse party was delivered by a court not competent to deliver it, or is obtained by fraud or collusion. I am avoiding fraud or collusion. I am only dealing with delivered by a court not competent to deliver it. A had filed a suit against B. He had obtained a decree. B subsequently files another suit against A for the same relief in respect of the same subject matter. We know Section 11 CPC bars that suit. Principles of res judicata. But if B is able to show that the court which granted the decree was not competent to give the decree, not because of want of territorial or pecuniary jurisdiction, because of some inherent lack of jurisdiction, certainly, notwithstanding that judgment, notwithstanding what is contained in Section 40 regarding res judicata, it is open to the defendant in the previous suit, who is the plaintiff in the present suit, to show that the judgment was delivered by a court not competent to deliver it. Therefore, when we read Section 9 CPC, we can't just confine ourselves to Section 9. We'll have to read 10, 11, and 12. Some provisions of the order portion of the Civil Procedure Code, which I have said, number of special enactments, Section 44 of the Evidence Act, which corresponds to 38 of the new enactment, and these principles will have to be done. With this, I am done. If there are any questions not pertaining to any pending case, no, it's not proper for me to give any advice. I have ceased to be a lawyer. I am not doing any consultation. I don't entertain any question with regard to a matter pending in the court or in respect of a suit proposed to be filed or contemplated to be filed, nothing of that kind. On a question of law, if there is any clarification required from my side, if without further investigation, when I am making it clear, I am not very familiar with the provisions of the Surface Act or the debt recovery, only for purposes of telling you which provisions are the jurisdiction of the court. I have just highlighted it. I am not very familiar with the provisions of that act. If there are any questions with regard to the aspects that I have covered, not in respect of any pending suit or not in respect of a contemplated suit, nothing. I am not giving that advice. On a matter of principle, I am not doing any consultation because I believe consultation is the work of the lawyer. So I am not practicing as a lawyer. So I have confined myself only to Judicial Academy and these things and arbitration. Therefore, please do not ask any question because from my experience, I'll be able to know whether it is in respect of a pending suit or not. Let there be no question in the guise of getting answer to a pending matter. Let there be no questions. Otherwise, with regard to a question of law which I have discussed, if there are any questions, if I am able to answer it without further investigation, I'll be pleased to do it.
So thank you so much, sir. As usual in your erudite fashion, sir, you have touched all aspects of the topic. Now we'll take up the questions, and now I would request the participants, if at all you have any questions, you can hit the raise button so that I would unmute you and you can directly pose the question to our resource person. I repeat, any participants has any question, you may hit the hand raise button. Immediately I would unmute you. Mr. Krishna Kirtan, I think you have a question.
Yes, please.
No, sir.
I could see that hand raise. So,
No, it was by mistake of touch, I guess.
all right.
Good presentation, sir. But unfortunately, at present, I will need to go through a lot of notes. I made notes of your judgments which you have mentioned, and I'll make use of them, sir.
No, in his
You are
usual,
practicing on the civil side, Mr. Kirtan?
Yes, sir.
You are
I have just
practicing
started about 8 months now
where? In Bangalore or elsewhere?
in Bangalore.
Attached to a senior or an independent office?
Yes, it is under a senior, Mr. Madhusudan Reddy.
All right. Do we have any more any questions before we wind up the session? Sir, I think that's it for the day, sir. Once again, sir, thanks for your time. Thanks for sharing the knowledge. And you have always been accommodating us with all your arbitration judicial academy work. I'm so indebted to you, sir. Once again, on behalf of Advocates Association Bengaluru, Advocates Academy Bengaluru, and my personal behalf, sir, I extend many thanks to you. Thank you so much.
I also thank you, Mr. Trivitram, because you have been giving a number of platforms. You are also a coordinator for the entire program. So you have been doing excellent work. Keep it up.
Thank you, sir.
So long as you need me and so long as you can assist me technically, I'll be happy to do it.
Thank you, sir. Very kind of you. Thank you very much.
I prefer to have discussion more on civil laws. Let me make
Definitely,
it,
sir. Definitely.
because the reason is, as you know, I'm doing arbitration, no occasion for, except when I speak on some subjects on criminal law in the academy. My love is for civil law.
Right.
Not that I'm averse to that, or not that I'm aware of it. Every day new. Now that some participants were there last week also, I forgot to mention. I repeatedly told the participants on the last occasion that the bar, uh, there is no bar for the under the NI Act 138 for following the new procedure contemplated by this 223. I gave two decisions, one under section relating to defamation under 500 IPC, then 138. The decision under 138 had followed an earlier decision in relation to defamation. Now, Mr. Trivikram has brought to my notice a subsequent decision in which the earlier decision related to 138 has also been referred to. And of course, in view of that latest decision, what I told you on the last occasion, perhaps is forum non juris. It will have no effect because it is the, of course, that is why we will have to keep ourselves updated. That is this is the decision. This is criminal petition 101514 101514 of 2025. 101514 of 2025 dated 28/4/2025, because that decision which I told you on the last week, that is of February 2025, that February 2025 decision also is referred to in this decision of 28/4/2025. Parties names Ashok versus Fayaz Ahmad. So 101514 of 2025, date of judgment 28/4/2025. There is also a direction for reporting. You may search whether it is reported. Ashok versus Fayaz Ahmad. So it makes a reference to the decision rendered in February regarding 138. Therefore, in view of this decision, which has clearly gone in greater detail, saying why that it has said that the earlier decision has not taken note of certain things. So this being a later decision, we are bound by it. So till such time the Honorable Supreme Court takes a view in this regard, and or there is a later decision of our Honorable High Court, as practicing lawyers, you are bound by this judgment, where you appear for the accused or for the complainant. So there is no need to follow the new procedure contemplated by 223, if I am correct, of BNSS with regard to compliance at 138. I may have my own view, but for practicing lawyers, certainly it is a decision which they are bound to follow. In fact, I wanted to tell it, but in the process I forgot. So, okay, good night.
Yes, sir. Before we wind up, sir, I would like to mention that Thursday at 7 o'clock, 6 o'clock, I'm sorry, we have one more session on matrimonial laws and highlighting on Guardian and Wards Act, mostly the child custody aspects. by the former principal family judge, Madam Prabhavati Hiremat. Madam has just demitted the office, so I have to invariably use the word former. Therefore, I would expect all of you to again log in on Thursday at the evening 6 o'clock. And we would also look forward for many more sessions from Sir Somashekhara, sir. Once again, sir, thank you. Good night.